Well, good afternoon, everyone. My name is David Tingstad. I'm the chair of the Business and Real Estate Group here at Beresford Booth, and another thrilling episode of our webinar series. This one is a fascinating one. I'm here with my colleague Todd Cook. Todd, you come at this from a little different perspective than I do. You want to maybe introduce yourself and tell folks what you do?
Sure. Hi, my name is Todd Cook. I am a litigator here at Beresford Booth, and I have going on 20 years of experience in civil litigation, primarily representing business defendants over the course of my career.
And so I'm on the transactional side, and it's interesting how much Todd and I work together, even though I try to avoid litigation like the plague. But there's some interesting carryover, particularly in this area that we're going to talk about today. And it's probably a very, I don't know, I would say misunderstood sort of distinction that we make in terms of a direct claim and a derivative claim, and the implications both in litigation and in the transactional world for why this matters. And it really does matter. And so what we're going to talk about today is, first of all, trying to get our hands wrapped around what is a direct claim and what is a derivative claim. So a direct claim is really what you would think it is. If I've breached a contract with Todd, Todd has the right to sue me. Todd and I are both the parties to the contract. And so on the slide here, a direct action seeks to redress harm, move my screen here, to a particular individual and not as a consequence of damage to an entity that the individual holds an ownership interest in. So it's just Todd and me. I breach, Todd sues me, direct action. But in a derivative action, now let's take a different example. Let's say Todd and I are members of the Todd and Dave LLC, and let's say that I'm in a separate entity. I'm the landlord, and I'm breaching my duties as a landlord. And Todd says, "Well, we need to make the Todd and Dave LLC, who's the tenant, we need to make that LLC sue Dave because I'm being harmed here, albeit indirectly." Well, that would be a derivative action because Todd's interest flows through that LLC. And so Todd doesn't have, and nor do I, have an interest by operation of law. We don't have an interest in the assets of that LLC. We can't make that LLC do something unless it wants to. And in my example, it would take both Todd and I's agreement, because we're 50-50 members, for our LLC to pursue my landlord LLC. And so that Todd needs to have some method to cause our LLC to, as the slide says, seek redress on the entity's behalf. And so what has developed over time is this concept of a derivative action. And there's some process that's involved between, look, if Todd is just suing me, he can start a lawsuit anytime he wants, but not so when it comes to a derivative action, because there's some process involved. So that's so first thing we need to understand is exactly what the difference is. We'll talk about why it matters here in a second.
Hey, David, can I step in just for a second?
Yeah.
Because I think that you've done a good job of describing the difference between a direct and a derivative action. And it's fairly easy to say what the difference is. And it's also easy to give examples that are clear cut. But just to be clear, it's oftentimes not clear cut. And there's oftentimes a lot of analysis that a court has to do to really figure out, is this a direct claim or is this a derivative claim? And so, the the example you gave with the contract where you have a personal right to compensation under that contract, that's a fairly easy one. And another one that comes up is, for example, there's an LLC, but and you're a member of it, but you're also an employee of it. So you have an employment agreement, or let's say you became a member, but there was a period of time when you were an employee before you were a member and you weren't paid. You know, compensation under an employment agreement would certainly be direct. So it isn't always easy to tell. So they have developed tests that the court uses that we can get into.
Yeah, no, I appreciate you hopping in there. You're exactly right. The title of the presentation makes the direct versus derivative conundrum, and you've just highlighted the conundrum. It's really difficult. Easy to talk about what's direct versus what's derivative, but in practice, it's really hard. Another example would be like fiduciary duties. Is that a manager has fiduciary duties, duty of loyalty, duty of care? Is that a direct claim that you might have if I were the manager? And they're really difficult. And so you're right about the tests, which we'll talk about. In fact, maybe what we could do, Todd, I'm just about ready to flip the slide to why does it matter. But is this a good time? Maybe you could talk about exactly what the court, how the court looks at it and what the test is.
Sure, that works for me. So in Washington, where we have, you know, a great business environment, we still look oftentimes to Delaware, where it's really the epicenter of business law. So there's a lot of Delaware case law that gets imported into Washington. So there's really a test developed in Delaware that we refer to as the Tooley test, that came out of a case with a participant named Tooley. And even that test, though, it's easy to state, and stating it doesn't always draw out really and distinguish the difficulty of it. But it's a fairly simple test, and they're looking really only at two things. And the first is, who was the person who suffered the harm? Did the individual suffer the harm, or did the entity suffer the harm? And that oftentimes requires a close analysis of the governing documents of the entity, because that document, you know, will set what the members' rights are, and it could establish duties that are duties to the entity, and it could establish duties that are duties to the members. So the first thing is they're looking at who suffered the harm. And then second, who would receive the benefit of the recovery? So someone is suing, and if you win in that suit, who is that money going to go to? And oftentimes it is really in the derivative action, it is that they are suing because the company has suffered some legal harm, and the recovery would go back to the company. Just one more thing I'd like to say about the test. They've described the test really in terms of what is needed to show that is a direct claim. And to show that a claim is direct, the proponent of the direct claim must demonstrate that the duty was owed to that individual, not just to the company, and that they can prevail in the action without showing injury to the company.
Yeah. So yeah, and so great. We have these great tests, and the court has spelled it out for us, but it is far from simple in practice to figure out oftentimes the difference, and the difference really matters. And so as I go to this next slide, you know, why does it matter? Why would a court go to the trouble of, you know, developing a test like this? And really, it goes even to the very beginning of a lawsuit, because if I'm not a member when I'm bringing the lawsuit, I do not have standing to bring a derivative claim. And so in the LLC context, it's you have members and you have transferees or economic interest holders. In other words, somebody who may not have a vote, may not have a right to look at the books and records, and nor do they have the right to bring a derivative action. So think about this. Even though I have an economic interest in an LLC, if I am not a member, the LLC can be off doing things and being harmed, and therefore derivatively I am being harmed, yet I don't have a right to bring an action to cause the LLC to stop itself from being harmed. And so there's been a ton of case law that has arisen out of the LLC world for this very reason, that because we don't have quite that distinction in the corporate world. In the corporate world, if you're a shareholder, you have the right to vote. There's no sort of middle ground like we have with LLCs. And so you'll have someone, for example, who inherits their interest in an LLC. That person will not be a member. And for the LLC itself, if something is direct versus derivative, there's a difference there, because management in a derivative action has an obligation to do something when presented with a derivative action. It is going to need to investigate those claims, decide whether it's in the best interest of the entity to pursue that derivative claim, or simply allow the shareholder, or excuse me, I got to choose my words more carefully here, Todd. Yeah. Or if the member, allow the member to pursue the claim derivatively, or to ask the court to dismiss it out of hand. So right at the beginning, that distinction, because if you don't have standing, then you don't have the right to stand in front of a judge. And so if you're not a member at the time of the outset of the suit, you can't bring the claim. But not only that, and Todd, maybe you could address this, not just the process piece, but this idea of if you lose your membership standing along the way, what happens then? And then maybe you could address the CR 23-1 process claims too.
Sure. Let me just step back and give a little context on standing. You know, as a litigator, you often, these things aren't disputed, and you don't have to think a lot about them. But in every case, there's a couple things that have to be present. The court has to have subject matter jurisdiction over the case. The court has to have subject matter jurisdiction over the person, the defendant, or the defendant waives subject matter jurisdiction. And the plaintiff has to be the right person to bring the claim. And if any of those things are lacking, then the court really shouldn't be entertaining the case, and there's options for someone to move to dismiss the case. So we're focusing on standing, and yes, so you have to have standing to bring your claim, whether it's a direct claim or a derivative claim. And when you are bringing a derivative claim, really it is the entity that would normally, in the first instance, have the standing to bring the claim. It wouldn't be a derivative claim then, it would just be the company bringing a lawsuit in its own behalf. A derivative action happens when, for some reason, the company's not acting to bring a claim, and one of the interest holders in the company decides, well, I'm going to do it instead. So Washington courts require that the plaintiff, the derivative plaintiff, jump through some hoops to make sure that they actually do have standing, and the standing has to persist. And we'll get into that in a bit, because that is finding ways to make standing go away is a way that we can get out of these lawsuits at times. So under CR 23.1, that's the rule that governs derivative actions, and it requires some things that aren't necessary in a normal lawsuit. So first off, the derivative plaintiff has to file a verified complaint. That means they have to verify under penalty of perjury, all the facts that they're putting in the complaint that establish that they have the ability to file the derivative action. And the rule specifically requires them to plead that they have membership status. They're a shareholder or a member of the entity. They also have to prove, allege facts that this the lawsuit isn't collusive in an effort to confer jurisdiction on the court where it wouldn't exist otherwise. But then the last thing, and the rule uses the word particularity. Washington is a notice pleading state, so your complaints don't have to have every detail in them like they may in some other jurisdictions. But when a rule says you have to plead something with particularity, it becomes a heightened pleading standard, and you really have to explain facts that establish it. So under Rule 23.1, you have to allege with particularity the efforts that the derivative plaintiff made to request that the manager of the LLC or the board of directors of the corporation or the general partner of the partnership takes the actions that you're seeking. In the example you gave earlier of the lease, that they take action to enforce payment under the lease. And then you have to allege, so that's considered the demand. And then there's also an option essentially of futility. So this comes up often when, the claim is against, the alleged bad guy is the guy in control. And so if you made a demand against, David in the David and Todd company, and David is the manager, and, he might not be inclined to bring an action against himself. So there is an opportunity, if that is a relevant circumstance, to essentially plead with particularity the reasons why you couldn't make the demand or why you couldn't get the relief you're seeking in that demand. So basically describing why the demand would be futile. And as we discussed, if your standing is established, but then it ceases for some reason, that gives another opportunity for the defendant to try to get rid of the case.
Well, that's a perfect segue, because one of the things that I've been asking myself, A, in preparation for this presentation, and then B, while the presentation has been going on, we've been talking all about things like subject matter jurisdiction, personal jurisdiction, court rules. And I'm asking myself the question, what does a transactional guy care about these sorts of things? And so because I do care. And one of the reasons why is because there are some transactional solutions. And Todd just mentioned, look, if somebody loses their standing somehow, some way, then a lawsuit can be dismissed, because now that person no longer has the standing if they are suddenly no longer a shareholder, or if they're no longer a member or a limited partner. Okay. And so there are things that can be done. And I've listed two of the things. I realize I have 3 bullet points on the screen, but a reverse stock split is a way that minority shareholders can be eliminated as shareholders. Okay. And I've identified there, you may be wondering, why in the world is sound infinity there, and why is infinity spelled wrong? It is not spelled wrong, because that's actually a case, a 2010 Washington Supreme Court case, where a Kirkland auto dealership called Sound Infinity had this very issue with 3 shareholders, and they went through a reverse stock split. And I won't bore everyone with how you do a reverse stock split, but that reverse stock split resulted in one of the shareholders becoming a fractional shareholder, and the company, as a matter of right, had the right to buy or redeem that shareholder's share for what we call fair value. And in that case, the Washington Supreme Court held in no uncertain terms that the sole remedy available for that sale of that fractional share, because the shareholder had all kinds of claims and claimed breach of fiduciary duty, among other things. The court said, no, all of that is subject only to dissenters' rights as long as you jump through the procedural hoops. And that's why, from a transactional standpoint, that's what my job is to do. And as a result of the company being able to redeem that shareholder's fractional share, they were no longer a shareholder. And so they couldn't bring any of those other claims. All right. Similarly, and I'm sorry, the Washington Supreme Court approved that approach as long as you comply with the statute. And it's, by the way, not easy to comply with the statute for a reverse stock split. A bunch of procedures you have to follow. Similarly, what's called a freeze out merger is also available. Again, not going to bore everyone with the specifics of how that happens, but I'm simply saying these are transactional solutions where, as a transactional lawyer, you could carry out one of these transactions and all of a sudden, perhaps a claimant now is either no longer a shareholder or no longer a member. And as Todd said a moment ago, if you're not a shareholder and not a member anymore, you lose this idea of standing, even though the lawsuit already started. And so if you lose that standing, even though the transaction is proceeding, and even when the transaction, the lawsuit, as there's already been motions and a summary judgment that may have been entered or things of that nature, even though a lot of things may have happened, if you lose your standing along the way, you can't pursue any of these derivative claims. So a lot of times, these are things for whether it's the board of directors or the management to take a look at to see if there's not another way other than just the straight litigation resolution like you would have in a direct claim, that you might be able to, using some transactional methods, to cause somebody to lose standing and therefore no longer be able to pursue their claims, and to only have their dissenters' rights. And dissenters' rights, again, I'm not going to, this isn't all about that, but basically it's an appraisal process where the shareholder or member is entitled to what we call fair value. And so, but that they're no longer a shareholder, and that's their exclusive right. So, Todd, is there anything you wanted to jump in on that?
Yeah, I wanted to jump in on that. You had mentioned, a moment ago, that this could be something that a board of directors or a manager could look to as an additional solution when they're in litigation. That's absolutely true. But I think that I want to highlight that this is, in the law practice, litigators are often litigators and transactional lawyers are often transactional lawyers. But it's a real benefit to a client when there's a team and the team can collaborate, because when I'm litigating, I'm looking to prove my case, if it's, plaintiff oriented, establishing the evidence that will make out my case and allow me to prevail at trial, or if it's defense oriented, establishing evidence that will undermine the plaintiff's case. And I'm not necessarily always thinking about, is there some non-litigation way? Sure, I mean, litigators are always thinking about settlement options, but are there other, non-litigation ways to get out of this? And transactional people aren't always thinking about, what's going on with the litigators in the office. But this is a great opportunity, and Sound Infinity is a really interesting case that shows that, Sound Infinity to me says, basically, if you follow the law, then you get what the law says you get. And in that case, the defendants followed the law and a process that would, by following the law, legally divest one of the person that they had the dispute with of their shareholder status, and that would then render them no longer having standing in the lawsuit. So it is something that was really and the plaintiff cried foul, and this is outrageous and this is unfair, but the bottom line to the court was, no, this is how we set up the law, and maybe it seems unfair to you, but they're following the law. And and this is the outcome that it results. So I think that this is, it provides good insights to, law firms like ours, where we have teams of litigators and transactional lawyers who can look for, all the solutions to a client's problem, not just, how can we, marshal the evidence to win, but, what do we have at our disposal at law to help this client achieve the resolution that they need?
No, that's exactly right, and that's the point that I really wanted to drive home here is how a transactional lawyer cares about these sorts of things, and it's because I'm a part of a team, and I can hopefully help Todd as Todd helps me and Todd's team. It is why we do this, and we're looking for always looking for all kinds of different solutions. Certainly, starting to delve into this idea of direct versus derivative and how it plays out, why it matters. Just wanted to leave everyone with this, that we're certainly here to help. We've been doing this for a very, very long time. We care passionately about what we do, and we care about our clients' needs and working towards resolution, whether that's in a courtroom or on the transactional side. And Todd and I get the privilege of working very closely together, even though I don't dare step into a courtroom. It's certainly important that I have Todd to lean on, and hopefully I add some value to the team, to Todd's teams too. So Todd, I'll give you the last word, unless you're done.
I would just say you absolutely add value to the litigation team. This sort of solution, and we've had this in real life, and definitely the transactional lawyer will have approaches that a litigator may not have at the top of mind all the time. So I think this is very valuable, and thanks for having me be a part of it.
Well, all right, I said I was going to give you the last word. I lied. I just wanted to point out to everyone that take a look at, we've just started a Washington business law blog, and useful articles for business owners, whether from a transactional or litigation perspective, will be up there regularly. And so take a look at that. Again, Washington business law blog. You can look at the Beresford Booth website for the link to that. It's got some great articles by people who are heavily involved in this sort of stuff. So we'd want to certainly have everyone take a look at that. And next Thursday, I'm thinking, I'm not exactly sure what this topic is for next Thursday, but next Thursday at 12:15 will be another webinar. Take a look at that. Check us out on our YouTube channel. Until then, I tell everyone, give us a call. We're happy to help. Todd, thanks for hopping on. I appreciate it.
Yep. Thank you.